We talk about duty a lot. A juror's duty. You took an oath. The object is the discovery of truth. It is your duty to seek the truth. You are not to seek doubt. All of the evidence before you points to her guilt. It is not your duty to go through all of that evidence, to find all the holes that are unreasonable, and to come up with some hypothesis that it doesn't even make sense. Your duty is the truth. And see, the defense wants you to ignore all the evidence that points to their client's guilt. They don't like the truth. They're going to lead you in a different direction. That will not make sense. That is not reasonable. The defense is going to talk about the state's burden of proof beyond a reasonable doubt. As the state, we have to prove a case beyond a reasonable doubt. But that is just that, a reasonable doubt. The doubt of a fair-minded, impartial juror seeking the truth. If there's a doubt in your mind, it has to be reasonable to acquit. It cannot be a doubt that makes no sense that you have no answers for. That's not a reasonable doubt. All of the doubts that they're going to get up here and try to plant in your mind are not reasonable. And the evidence shows that. The defense is going to want you to believe that this standard is unattainable. They may even show that stair-step picture that they showed in opening of each burden as it gets higher and higher with reasonable doubt at the top. You cannot define reasonable doubt with steps. It is defined in the law. It is not to a mathematical certainty. It is not beyond all doubt. Beyond all doubt is unattainable. Crimes are not committed for everyone to solve and know about every single detail. Crimes are committed and concealed because no one wants to be caught. We are asking you to bring your common sense and reasoning into that deliberation room. Do not leave it behind. Because common sense and reason gets you through life. That's what you need to apply to this case. You make inferences, you can make deductions, and reach the conclusions based on what you know, what you've experienced, the evidence, your common sense. That's how you'll reach the verdict in this case. There are two types of evidence that the judge will instruct you on, direct and circumstantial. A lot of shows and podcasts and commentators, they all say, well, it's just circumstantial. Right? We've all heard that. But the law says you give whatever evidence, whatever weight to whatever evidence you want. There is no legal difference between circumstantial or direct. You could have the most convincing circumstantial evidence, and yet the direct evidence is just, well, maybe. Or you could have evidence that's actually both. Let me give an example. The other night, he was eating dinner at the table, and I ran upstairs to go get his sister's pajamas or something. We have a box of cookies on the counter by the cookie tin. And I come downstairs, and he had crumbs all over his face. There was a cookie missing. And so, based on that circumstantial evidence, I could infer my child stole a cookie out of that cookie box. I'm not going to infer that some cookie fairy came into my house and took it. That's not reasonable. But that is circumstantial evidence. Now, had the box been knocked over on the floor and the crumbs sitting there on the floor and my dog is laying on the couch licking his paws, well, that scene points to my crazy dog probably jumped on the counter, got a cookie out of the box and ate it on the floor. I don't have to see who took the cookie to know who took the cookie. So circumstantial evidence is a conclusion that you can reach based on inferences. Direct evidence is something you heard, saw, tasted, smelled, Scott seeing blood on the floor in the basement. All of the testimony you heard, those are things that they experienced firsthand, the witnesses. It's direct evidence. There is no legal difference. You give whatever weight to whatever piece of evidence you deem appropriate. The law allows you and demands that you determine who to believe and who not to believe. And some people, you can believe some things they say and not some things they say, right? Like Rusty Barton. He plays both sides. We know that. We saw that. We know what he said was the truth about her statement, he's in the burn pile, because of the context in which he said it. We know the recantation is a lie because it makes no sense. They will want you to believe that that burden cannot be reached and it is unattainable. They will get up here and try to instill upon you that there's no way we can ever prove this case beyond a reasonable doubt. Well, that is just not the law. The law does not require beyond all doubt. We need order and justice, and that means we prove a case beyond a reasonable doubt. You have more than what you need in this case to convict Melody Ferris. I want to talk about grave suspicion in your presence because I assure you that Mr. Ray or Mr. Weaver will get up here and talk about how we just have grave suspicion of Melody. She was merely present at the home when he died. No. We have way more than that.